All right, Lyric Armstrong, your real estate agent and advocate. We are back in Lenawee County. We are still on the Dee Warner matter. We have some closing arguments relative to declaration of death, but we're back to the original hearing that I thought was going for today, which is the court's order of findings for the show cause, criminal contempt against Dale Warner. So let's get into court. It's going to be quick because it's going to be the court order. I'm sorry, court findings. So this is going to be her ruling relative to did Dale Warner criminally commit contempt, which was him switching the companies. And we talked about that earlier. So this is the actual hearing that's about that. The other hearing turned out to be the declaration of death. This one is about Dale and his potential nefarious acts. We're going to find out, was his acts nefarious or not? Take care of that housekeeping. I did my liking, so you do yours. Like, share, and subscribe. This is how people get informed. Why do we care so much, other than the fact that it's a very high-profile case? I got on this case because I was looking at probate matters and things that affect probate matters that make probate matters so long and expensive. You will even remember, if you've seen the video, that the petitioner's attorney, it's like, this is costing, or one of the guardian litem said, this is costing a lot of money and time, a lot of resources, because it's costly to go through probate. And this particular scenario has a lot of layers, a lot of allegations on the fly, death, murder, nefarious criminal activity, financial frauds, whatever, IRS evasion, like it's got all the things. It's got all the things, more things than we thought we were going to get. And so that's why we're here, because we got here looking for probate, and we found an evidentiary hearing for motion to compel, which put Dale Warner in civil contempt, and he was in jail for that, him and Weisberg, both of them, because they weren't turning over their information to the conservatorship as they were supposed to. And they were holding up the process, if you will, making it more costly, if you will. So they were found guilty of that. So they did that. So now we're going to find out about the criminal activity of moving money and disregarding the court's order to not diminish the assets. And does it qualify that if you stop doing business under the business that's generating money, and you do that exact same business under something else that only has your name to it, is that in fact diminishing the assets? If you recall, Dale attorney brought up the defense that Dee and Dale are still married. This is where we're getting into this crazy, she's missing but not dead. So that's when they were confusing the crap out of me. I'm like, I could have sworn we said she was dead. Well, guess what? Today was actually the hearing to determine that. And that was the previous video. So if you didn't see it, go check it out. This video, we're going to get into contempt. All right. So it should be quick, 15 minutes for court, I would think. This is just the attorney. What happened? Did I press the button? Let's see what happened.
51852C8. We are back on the record for the court's findings on the opinion on the motion for show cause.
All right. And we can't see the judge all day.
Names of our participants, please.
Listen, if you've been on this video with me, you know that I've been complaining that I can't see the counselors because they're objecting. You got to remember the voices to determine which one is objecting, because you can't see them. They're at the podium. And they were doing a lot of that the last time, right? So now I can see them, but I can see the judge, and she's the one that's getting ready to give the rulings. And this judge gives me life because she makes facial expressions that truly express how I feel when I hear some of the objections, and I can't even see your face. All right, judge is getting ready to give her ruling. Here we go.
Good morning, Your Honor. John Polderman on behalf of the successor conservator, Charles Bullard.
Hands up.
Good morning, Ariel Berger here on behalf of Dee Warner. Suzanne Wilhelm, for
Michael McFarland, attorney guardian ad litem for Dee Warner.
Morning. Good morning, Your Honor. Larry Lee, appearing on behalf of the Dee Warner, who's seated to my right.
Thank you. So today's the date and time for me to give you my findings. I've done a written opinion, and so I will just be reading that into the record, and all of our parties and attorneys will be given a copy of this at the conclusion of today's hearing. In a session of court held over the course of several days, including April 12th, 2023, June 6th, September 8th, and September 13th.
Have you seen that new slimming chocolate that's been going viral on TikTok?
The absolute heck. I know you're watching something good. Here they come. All right, let's take it back.
In a session of court held over the course of several days, including April 12th, 2023, June 6th, September 8th, and September 13th. Now comes the court duly informed by the pleadings and testimony and issues the following findings in support of its order of contempt of court. The court finds that defendant Dale Warner is guilty of criminal contempt beyond a reasonable doubt for the following reasons. On September 15th, 2021, a conservator was appointed to inventory and secure all assets of missing person Dee Warner. This was later clarified to include any and all assets that she may have an interest in, given that she is a married woman and would therefore have at least a half interest in all assets of the marriage, including real estate, business interest, equipment, and all other marital assets. Dale Warner resisted the conservator's efforts, and the court had to enter an order on January 14th, 2022, specifically indicating that Dale Warner is enjoined from attempting to sell, dispose of, transfer, encumber, or otherwise diminish the assets of DDW Investments LLC, diverting business away from DDW Investments LLC, altering books, records, accounts, or other information, however kept or stored of DDW Investments LLC, or possessing any assets of DDW Investments LLC, which shall immediately be turned over to the conservator. The court had to issue an additional order on September 22nd, 2022, concerning specific assets of Warag Farms as a result of Dale Warner's actions in thwarting the efforts of the conservator in taking inventory and responsibility for the assets and interests of Dee Warner. As the case progressed and numerous other issues, Dale Warner's refusal to cooperate with the conservator continued, incurring thousands of dollars in conservator and attorney fees taxed to the estate. Finally, the conservator filed this request for sanctions for criminal contempt, which was addressed by testimony from both conservators, family members, business associates, and other professionals detailing egregious and costly rearranging and sale of the assets of the conservator estate. The following uncontroverted facts demonstrate repeated intentional violation of this court's January 14th, 2022 order. This contumacious conduct crippled the functioning of the conservator and therefore the functioning of the court and its oversight of the conservator and the estate. First and simply, failure to terminate from employment Mark Weisberg, who was supposed to be terminated from employment pursuant to the January 14th, 2022 order in the very first paragraph. Continuing his employment and authority in the farming operations, resulting in his spearheading many of the actions that Dale Warner now finds himself responsible for, including the movement of assets and funds away from DDW Investments, defrauding the IRS, hiding of records, and the eventual sale of the largest asset of the estate, the trucking company. The uncontroverted testimony of Russell Dempsey, initial conservator, supported by a review of the records, described the willful disregard for the conservatorship and the conservator in the following ways. First, Dale Warner and Mark Weisberg's intent to, and accomplishment of, bankrupting DDW Investments, which was formerly the income-producing entity that kept both the transportation company and the farming operations afloat. This is pursuant to the credible testimony of Zach Bach, family member and former employee of DDW Investments LLC. Mr. Dempsey described the alterations of DDW investment accounts as a result of his review of the QuickBooks records, noting several entries for, quote, rent owed by DDW Investments that was unsupported by any agreements or past practices, and amounts that rendered the company insolvent. Incredibly, these adjustments were supposed to operate retroactively to 2014, causing even the accountant to be alarmed. He also noted the diversion of income from DDW Investments to a new company called DDW Transportation, established in August of 2021. Finally, he noted the cannibalization of DDW investments via the practice of paying expenses out of the account without allowing deposits of income immediately after the entry of the January 14th, 2022 order. He describes the discovery of a loan Dale Warner secured in November of 2021 that further compromised assets, none of which was disclosed as ordered on January 14th, 2022. He testified that in order to review bank records, he had to go to the bank and through formal channels. He testified that he was literally physically prevented from completing a personal property inventory by Dale Warner's attorney, and that the lion's share of the jewelry had disappeared compared to records of purchase secured by Kay Jewelers. The diversion from DDW Investments account at First Federal Bank was established through the records and testimony of witness Russell Dempsey. This is a direct violation of the court's January 14th, 2022 order and impaired the function of the conservator, therefore impairing the functioning of the court. This preceded the most egregious violation of the order, which was the sale of the trucking company formerly run by the DDW Investments LLC. The sale of DDW Transportation is the most egregious violation of the court's January 14th, 2022 order, since all assets owned by this company were formerly owned by DDW Investments. Testimony from Todd Nyrick dispelled any illusion that the assets of DDW Investments were different than DDW Transportation. Other than changing which side of the desk he sat at, Mr. Nyrick continued to perform the exact same functions for both companies, using the same methods, procedures, and assets. He testified, rather colorfully, that the only thing that changed was the name of the company. Regardless of the name of the company, this company was an asset Dee Warner had a substantial interest in, and the sale of same was conducted by Dale Warner intentionally without the involvement of the conservator. In fact, Russ Dempsey testified that he asked Dale Warner point blank if he was selling DDW Transportation, and Dale Warner responded, absolutely not. Only to find out later that literally a signed purchase agreement had already been executed on June 17th, 2022. The sale of this asset cannot be characterized by any other word than intentional. Transference and sale of the company was specifically addressed in the concerns raised by Russell Dempsey in his motion and affidavit filed in support of the January 14th, 2022 order. The order itself addresses a direct prohibition against the sale of these assets, and Dale Warner lied directly to the conservator about the sale. The conservator had not taken action to secure these funds. This would have been an $824,000 windfall for Dale Warner at the expense of the Dee Warner conservatorship estate. The diversion of funds secured through a small business loan to Dale Warner personally is a course of events that straddles the entry of the January 14th, 2022 order, but also involves contumacious conduct intentionally in violation of the order. Dale Warner, unbeknownst to the conservator, had secured an SBA loan on November 13th, 2021 for $1.5 million, 2 months after a conservator was appointed. There is no question the conservator should have been consulted on a transaction that could have such a devastating effect on the assets of Dee Warner. There is no question Dale Warner was aware of the conservator, who had already been asking for business operations information for 2 months at that point. The initial disbursement occurred prior to January 14, 2022, but still constitutes conduct that impeded the functioning of the conservator and therefore the court. This must be restored to the estate at a minimum. The failure to disclose this loan after the entry of the January 14, 2022 order is directly in violation of the order. The subsequent action of taking the March 25th, 2022 disbursement of $929,200 as a loan to himself is also a direct violation. This move also demonstrates Dale Warner's clear intention to undermine the conservator's efforts to secure Dee Warner's assets and interests, and therefore subvert the authority of the court. There is no other way to describe this conduct than deliberate. The practical effect is to devastate the corporations formerly funding the transportation company and the farming operations in order to simply award Dale Warner a windfall sum.
Warning, you could soon lose your job because of what's happening inside this building you see behind
Operations in order to simply operations for misconduct than deliberate. The practical effect is to devastate the corporations formerly funding the transportation company and the farming operations in order to simply award Dale Warner a windfall sum. Further action that demonstrates the intentional conduct of Dale Warner in these events is the exchange around crop insurance that took place in October of 2022. To justify the redirection of funds from War Ag Farms LLC to Dale Warner personally, Mark Weisberg delivers a complete fabrication about the FSA requiring land certifications being in an individual's name. This is clearly an effort to redirect the conservatives' attention from the diversion of funds, which worked for approximately a month, until communication with USDA County Executive Director Jessica Mullins confirmed for Mr. Polderman that this was not required for crop insurance. Dale Warner took these actions, then covered them up himself or with the help of Mark Weisberg. His actions demonstrate criminal intent beyond a reasonable doubt. The court has a responsibility to ensure that its orders are followed. In such a public venue, this egregious and flamboyant disregard of the court's orders for personal gain cannot go unaddressed. Dale Warner's actions have devastated the conservator estate of Dee Warner. The estate is loaded with debts with no apparent way to recover due to the sale of the only profitable operation that historically sustained it. Many of the assets have been sold or disappeared in what has clearly been an intentional scheme conducted by Dale Warner for his own profit and gain. He has used overt and covert methods to distract court officers, attorneys, and conservators, while he rapidly gutted the interests of Dee Warner. The court must act to address criminal conduct to prevent future action in other similar cases and restore respect for the operation of a conservatorship under the law. Therefore, it is ordered that Dale Warner is sentenced to 93 days in jail for multiple contumacious and criminal actions taken against the conservatorship estate of Dee Warner and for direct violations of the court's January 14th, 2022 order. Upon his release from incarceration, Dale Warner is sentenced to a period of probation for 6 months, during which he must report monthly to a probation officer, pay his fines, and follow all other orders of the court. It is further ordered Dale Warner is assessed the maximum amount of fines and $7,500 and must also pay all attorney and conservator fees generated as a result of his contumacious conduct that resulted in the thwarting of the conservator's fiduciary obligations. It is further ordered he will also be required to make the estate of Deanne Warner whole for his willful and knowing violation of this court's orders. Officer.
Your Honor, before sentence is carried out, may I speak for the record, please?
No,
Stand up, Mr. Warner.
Your Honor,
Court's in recess. We'll take up the next matter in a few minutes.
Judge, I love her. I love her so much. She's my bestie. We don't agree on everything, but I love her style.
where's he?
Dale Warner is under arrest for criminal contempt. I don't know what he wants on the record, but it's in, of course, in recess. So I don't know if he's gonna get it on the. I think that's it. Oh, he's happy as pie. He's like finding a little bit of justice. Yep, that's it. Going, as I said before, the court just cuts the feed. That's how they do their thing atypically. So that last little bit of like insider addition, it's not normal for this court. Okay, so we talked about this at the last hearing relative to wow, that was eventful, huh? The last hearing relative to contempt, his criminal contempt, was what he was trying to overcome in his defense of his actions were relative to saying to the exact same judge who put the order in. Like it's one of those things. Like I gave you the analogy. If your parent tells you not to do something, but your best friend says, oh, it's okay, or your teacher says, oh, go ahead, you can do it. You cannot just surpass what your parents said and just do what someone else says you to do in contrary, right? Because that means your parent is still going to be upset with you because they gave you a direct order not to do something. Well, that's what the judge did. The judge gave a direct order not to do something. And Dale's defense wanted to have his other attorney, not the one that represented him in this case, but his business attorney to come up and testify That attorney happened to be busy doing a trial, right? And so he couldn't testify, but he had a written affidavit that if the court was so receive as evidence, then they could take the written affidavit. They lost that because a part of testimony, having a witness, is that the other side gets to ask questions. And so we learn and we know that when you have direct examination and then cross-examination comes up, you have redirect, and redirect is based upon new information that comes out in cross. So just because you have all the direct information in an affidavit does not mean that there wouldn't be some new information in cross. And you, by having an affidavit of a witness, are eliminating the ability for the cross-examination process. And so there's rarely any instance where the affidavit would be entered. In some criminal matters, it has been something like a deposition that gets entered because that person is dead. Same thing with probate. It might be the deposition of the will and testament that gets entered because that person is dead. So, and I say deposition, I'm talking about recording video. So maybe that, but in this case, that attorney did not get in. And so his attorney kept trying to do a closing and kept trying to assert to the factors that he was advised by counsel to move the money around the way he did it. He was advised by counsel to shut down Dee's company and open up his own company, doing the exact same work with the exact same assets that her company had because they were avoiding the IRS. Because her company owed a whole lot of payroll taxes is what the representation was in the case trial, the hearing. You know, whatever. Because if you think you can get away from the IRS, you are sadly mistaken. They will follow you to the next company. But whatever. So that's what they said that they were going to do. The judge, of course, it doesn't matter. Oh, and then the other thing that they asserted as a defense was that a lot of the stuff that they were being accused of doing had been done prior to the order. So she put the order in January, and this is stuff that was done in August the year before, September, November the year before. But they never informed the court. They never told the court that they had done these new activities. And they were eluding the conservator and the conservator's inquiries as to where's the funds, what's going on. So how do you explain that there, sir? Other than you're just trying to skirt the court order, not the IRS, because the IRS is gonna find you. I don't know how you think the IRS is not gonna find you. The court may not be able to find you unless someone else gets wind of it, which happened. That they got wind of it. One of the conservators says, I'm being told that there's some kind of sale going on. And it turned out that they were selling Dee's company or selling his new company. I think he was selling his new company to another party who actually has all the same assets the Dee companies had, the furniture, I believe the equipment, but most assuredly the clientele. The clientele list just kept going from one company to the other. So all nefarious activities. And the judge, under like what circumstance would you believe? What circumstance do you expect the judge to believe that you were not doing this in direct defiance of her order? Her order was explicit. It said not to diminish the asset of the company that was in place, which is Dee Warner's company, to not sell the asset, to not close it down, to keep it operable, to keep making sure that the funds are still in motion and still coming in, and to report all things to the conservator. And you weren't doing any of, you were going against all of those factors, but yet it's only because of the IRS. That defense did not fly. Clearly, she found him guilty. One of the things we learned in the other video is that for the declaration of death, they had to have clear and convincing evidence, because they kept crying about, well, this is not a criminal, this is not criminal, it's clear and convincing evidence. And it wasn't civil either. It's probate, and it was relative to declaration of death. So it wasn't just preponderance of the evidence. It's clear and convincing evidence is what the standard is. And so she hasn't had her ruling on that particular hearing yet, but they had their closing arguments on that today. This ruling is from a couple days ago, and she reminded them, since it is criminal, it is beyond a reasonable doubt, right? So criminal evidence, criminal activity, criminal conviction is based on beyond a reasonable doubt. And the evidence she finds was beyond reasonable doubt and convicted him, clear and without a beat, you know, guilty, beyond reasonable doubt. These are the factors. And this is a summation of what her written order is. So she has some more details probably in the written order. She has to make the company whole. And they have a hearing. I don't know, I had to find out what it is, but they do have a hearing that's going to kind of factor out what does that financially mean? Because you're talking about the conservatorships hours, you're talking about the, well, they said 900 and some thousand dollars. There was a personal loan to him. I don't know if he ever made any repayments, but he took a personal loan out from the company for almost $1 million. The loan he tried to get for the 1.5 million, I think, is the loan that started the process because they felt like the power of attorney was a forgery. And I don't think they ever gave him that loan, but he at least attempted it. So they're going to have to go and sift through the financials to determine what actual money was taken from the company, what did it cost them to investigate the circumstance of the conservatorship, and then whatever things that they find is necessary. So his actual financial responsibility will be calculated later. The $7,500 calculation is the fine. That's like when you go and you pay your ticket. Your ticket's $5, but you got to pay $450, right? The rest of that is the fine, and the ticket is $5. You know, so that's what his $7,500 is. It's the fine that goes along, and they said that's the max. Everybody will look into that. $7,500, especially for a case like this, maybe some other cases that are not so financially strong, and you know, like I said this before. You're not fighting over money or business unless it's worth something, okay? You're not going to fight over pennies. You're like, whatever, take the stupid thing. The car don't work, it ain't worth nothing. Go ahead, take it. You know, I'm going to just hate you forever and talk about you behind your back. But to spend money with an attorney to fight in court over it, it has to be worth a substantial amount of money. And we've come to find out that the business that they had were worth a lot of money, a lot of millions of dollars, not $50,000 here, there are millions of dollars. So the 7,500, that may be something you guys might want to reform in Michigan to get that, at least the cap. I mean, you can still keep the minimum, but the cap, this is the maximum amount that they're allowed to submit as a fine under these circumstances. And I think a case like this would warrant a little more money is a fine, but nonetheless, he's only having to pay $7,500 towards the fine. Making the estate whole and correcting all those financial things, we'll find out later how much he has to come out of pocket for that. He got the 93 days. And I believe the 93 days, I know it's what was requested by the petitioner when they did the closing, but I believe the 93 days is the max for this particular contempt. So he got a substantial amount of time. The last time he was put in jail for the civil contempt, I believe was on like a week or two, even though he felt like it was egregious because he wanted to get out and felt like everybody had what they said they didn't have, whatever. He had to stay until everyone could attest to the fact that they had all the documents in that particular motion. And that's how we got into this case, was the hearing relative to the evidentiary concerns about them not turning over pertinent documentation to the conservators. And then he'll have 6 months of probation. Yeah, $93 in jail, 6 months of probation, $7,500 fine, plus restitution. Restitution is the element of making the estate whole for the millions of dollars or million-something dollars he took out of the business that he wasn't allowed to do. You see why you let professionals do professional things. So here's the thing that gets me. I said this during the closing for this particular hearing. He claims that his business attorney told him that this was a great business idea to keep his business afloat, was to close down the old business, which is the business, and then open up his own business, which was his Dale business, and just to do all the same contracts with all the same workers and all the same clients, right? Don't believe, I don't believe, could be wrong, but I just don't believe that a seasoned business attorney would say to you, yeah, go ahead and do those things and don't tell the probate court. I don't believe that I don't believe that that attorney knew that there was an order in probate. And that's kind of also backs up the evidence, because the probate order was in January, but supposedly the business shuffling and jiving happened months before the probate order for most intensive references relative to like changing the business name and opening up a new business account. Like that stuff, I believe, was done before the actual order went into place. But a business attorney, all attorneys, I mean, employment law lawyer attorney, employment in law labor attorneys know, all attorneys know you don't go against a judge's order. So I don't think they ever went back to the business attorney and said, oh, look, the judge put this order in and we've done all this stuff last couple months ago. What do we do now? Are we good? How do we proceed? And if you did, and that attorney says, yeah, you're good, don't tell the judge anything, that attorney would be in trouble. Now, that attorney did not take the stand. So those details did not come out. We don't know. And it might have been the reason why the attorney didn't take the stand. I'm sure that attorney had a trial and couldn't get out and needed to be at trial. But just like it was stated, if the attorney was so vital to Dale's defense and the factors, they should have subpoenaed him. And then the trial would have had to been on hold and suspended. Now, the judge over there would have been upset, but nothing you can do about the fact that he's being subpoenaed to testify. And they did not subpoena him to testify. They related, though he can't make it because of the trial. He was supposed to get on Zoom at 2:00, which is a terrible time to get on Zoom because typically you're back on the record at 2. So even in that doesn't become logically sensible, because courts are in recess from 12 to about 2. From 12 to about 2, 12 to 1:30. I think it's 1:30 because the next docket comes up at 1:30, right? And so when you're calling your clerk's office at 2:00, they're whispering. This is how you know if you do business, okay? If you really are the attorney you say you are, you know for a factor that at 2:00, if you call the clerk's office to set a hearing date for your motion to compel, they're, yes. They're whispering. And why are they whispering? Because court is in session on something else. So it's abnormal to say 2:00. 2:00 is a weird time to say, oh, he'll be available to testify at 2, unless maybe he was going to have his other attorney get up at 2 and represent in trial so he could run the hallway to go to Zoom down in one of the rooms. You can also petition the judge and say, Judge, I am supposed to be testifying in this other case. Can we come back from recess at 2:30 so that I can go testify at 2:00? Judge may be irritated, but everybody get a little 30-minute more break. They might take that. Or bottom line is, you tell the one that you're testifying for, can you guys not take a 12:00 break and I come in at 12:00 during the break that we usually have? Maybe, maybe not. Depends on how things work, right? But whatever the case, he didn't testify. And that may be good, because if he got on that stand and put himself in problems, he would have problems with his license. If you, as an attorney, are advising your client to disobey a court order, do you remember Judge Simpson's case when he was yelling at one of the prosecutors? It's because now that's an act that gets reported against your bar, and you can have a not discrimination. What this oh God, it's not discrimination. What is it? What is it? Disparaging. I'm just gonna say disparaging. That's not really the word, but you have a disparaging point against your license. And so many of those will get you just disbarred unless you have a real grievance, and you'll get disbarred off the gate. But nonetheless, when you tell your client to not follow a court order, you're susceptible to having your bar license reviewed and go through hearing and have a ding against your license. So it's kind of good he didn't take the stand. However, depending on what he said in an affidavit, one of those attorneys might report him, because the affidavit is atypically sworn to, with the, penalty of perjury, I swear this is the truth, penalty of perjury, yada, yada, yada. So that's like a declaration. Affidavits usually have the same language, and they could report that to the bar. It just depends on what he says in there that makes it, if it's going to be an actual grievance or not. All right. I think we have one more hearing relative to this matter. We got to see Dale go to jail. Not for murder. We're still waiting on them days, but the case is open. He went to jail for criminal contempt. He is screwing up his screwing up his rap sheet. Whatever, if he didn't have one before, he has one now. He's gone to jail twice now, one on civil contempt and now criminal contempt. It's unfortunate, but this is why you don't pay fast and loose with court. It may be a slow process before they get to you, but they will get to you. It's just like the IRS. They can avoid the IRS. If you can avoid the IRS, put it in the comment section. Let us know. Be bold, because I had to find out. This is ridiculous. I've never heard of the fact that you can just start a whole new company and the IRS ain't gonna find out. When you put your name down as a CEO, they're gonna be like, wait a minute, let me do an investigation. And what happened today, the last few days? You have all this testimony that says nothing changed, just the name. Do you think the IRS didn't hear that? You think they don't know that? Please, they know. And here they come. They're going to be coming around the mountain in just a minute. Dale is going to be up the creek without a paddle. Unfortunate. What do we learn? Businesses are a part of, and the shares. Oh, she also went into that. Dee's shares into a company needed to be protected as well. We had talked about that before. So now you have a court order that shows you this is what court does. You're supposed to protect the shares of what her ownership is. So if she's a 50% owner due to community property, then you protect that property so that she can have her 50%. And that's what the court had ordered, protect her shares in the company, whatever she would owe 50% in, because she's a married woman to Dale. Protect that. He sold off property. He changed the company and, kind of erased her from there. He tried to put in the defense that since they're still married, she still has 50% shares in the new company, but you might have had that argument if you were being more proactive and upfront and said, Your Honor, you put this order in, but I already have a new company. I've already changed the company. It's already done, and I suspect that she has 50 shares in my new company, but I did it to, protect the financial interests and protect against certain taxation that was going on with the old company. But you didn't. You paid fast and loose, kept it from the conservator. The conservator had to dig and find out, do show cause hearings, do a lot of man hours and court hours to come to the conclusion of what you were doing and why. And the IRS knows all about it now. So you ain't avoid nothing. I hope he has some money to pull on because he got a lot of money to be paying out. You're gonna have millions of dollars to owe the estate. And now God knows how much money he's gonna owe the IRS. And be careful on that because we can always say, I have a judgment for $1 million. Did they pay it? Can they pay it? Are you ever gonna see the money? That's a whole nother argument, right? You get the judgment, you get the order, they're supposed to pay you, but all of a sudden now they have no money, so they can't pay you. That will probably be his defense in the next video. He'll be defending the fact he doesn't have the money to pay it. But for you and your probate matters, let's avoid probate, have a trust and a will, cover yourselves, cover your family, include all of your business interests, whether you own 100%, 50%, 70%, doesn't matter. Include those interests. Make sure all your assets are listed, whether personal property or bank accounts, real property such as houses, rental, mobile homes can be considered real property under certain circumstances, vintage cars, furs, whatever. She had diamonds and jewelry that she was buying from K Jewelers, $70,000+ that she was spending. She didn't have that in a trust. They had to go find that out from K Jewelers. So what happens if she went somewhere else to make a purchase? What happens if she went and actually, went to a reputable jeweler and got a specialty diamond? What about Cartier? Did she go there? Did she buy a Rolex? Did she go to Rolex and get a Rolex? We don't know. We don't know, right? Because she didn't have it in her trust. You make sure you put it in your trust. Have your things appraised. Take pictures of your itemized assets that are personal property and have value, whether that's a picture of a painting or some type of artwork or, whatever. Itemize that out and have an appraiser come, or your insurance carrier come. They're going to send an appraiser. Have them come out, take a look at your inventory list, add to it if they need to, put valuations towards it, and then make sure that that's accounted for in your trust. All right, let professionals do professional things. Make sure your professionals are professional. Nefarious activities are not covered by the law. And that's why I really believe that a lot of his quote unquote advice that came from his business attorney most likely came from Weisberg or whatever, who was convicted of fraud, that all this nefarious, move money around, change companies, keep everything a go in the same light, sell this off, keep that. Yeah, that sounds more like his co-defendant to me, but I'm just guessing, wasn't there. Those are my allegations and my opinions. I hope you learned something. It's a lot to learn in this case. Pay close attention. Avoid this type of drama. Stay healthy, whole, and may your relationships not end this way, but regardless of how they end, make sure you have a plan through your will and your trust. All right, Lyric Armstrong, your real estate agent and advocate. See you on the next video.